right, it's a little bit after 2 o'clock. We'll start the November 17th meeting of the Superior Court Rules Committee. I am Justice Bright, the chair. Present at the meeting in person, thank you all for coming today, is Judge Aaron, Judge Armada, Judge Doyle, Judge Green, Judge Griffin, Judge Mazurowski, Judge Torres, and Judge Welch. Now, welcome everybody to Supreme Court. The meeting is being streamed live for anybody who wants to see it. And with that, we will proceed with the first item on the agenda, which is the minutes from the October 6th meeting. They were provided to everyone as part of the materials for today's meeting. Is there a motion?
So moved.
Second. Judge Welch, Judge Aaron, second. Any discussion? All those in favor of approving the minutes from October 6th, please say aye.
Aye.
Any opposed? Any abstentions? All right, the minutes are approved. All right, the next item on the agenda is the proposal for the requirement that attorneys use AI programs who use those programs appended certification to their pleadings. We discussed this at the last meeting. I said I would work on some language. I actually had some discussions with Judge Bizzuto, who had received additional information from other states and asked me to consider that. I also had some discussions about the operational aspects of the proposal in terms of having the clerk's office verify that the certification was there, particularly in light of the e-filing that almost all pleadings are filed with. So I went back and I'm still revising that, and I hope to have some proposed language for everyone at the next meeting in December, which would also cover the next item on the agenda, 2023-014. So unless anyone has anything else on that, we'll just put that on the agenda for December. The next item on the agenda is 2024-013, proposal to amend discovery rules and summary process matters. I can provide something of an update on this from the Access to Justice Commission's standpoint. The matter was referred to the Access to Justice Commission last spring. We had a number of discussions at the Access to Justice Commission about that. Those discussions resulted in a very productive dialogue between court operations and the proponents of the proposed rule. And as a result of those discussions, a revised proposal was submitted, and that was in your materials for today. That proposal was a subject of the discussion at our Access to Justice Commission meeting last week. And Attorney Shea, who was the original proponent, is here and can discuss that. If you'd like to, let me just, I'll provide some summary as to what we talked about at the commission meeting. The Access to Justice Commission, after hearing a report on the revised proposal that was going to be submitted here, unanimously agreed that the proposal would support access to justice, and unanimously supported the agreed upon proposal from an access to justice standpoint. There were some concerns raised about a notice issue. Judge Berger, who is on the Access Justice Commission, discussed that with me and Judge Thomas, and he brought it up at the meeting, and I told him that was really a Rules Committee issue, not a Access to Justice Commission meeting issue for drafting purposes. But with that, Attorney Shea, if you would like to comment.
Sure. Thank you so much, Justice Bright. Thank you for having me, members of the Rules Committee. Just to clarify, I think that if I'm not mistaken, Justice Bright, I think that the unanimous Access to Justice Commission support was for the new practice book provision, which is part 2 of our proposal, which is mandatory disclosure of lease and ledger, which is the language negotiated with court operations with the help of Judge Thomas and mediator Travis Claxton. There's another part of the proposal, which is to shorten the time for production or objections to discovery requests in summary process from 60 days to 15 days, which is page 1 of the proposal, to better match the pace of litigation and summary process and the 3-day pleading schedule. And I don't think Access to Justice took a position on that part of the proposal.
That's correct. Thank you for that clarification. The Access Justice Commission considered 13-12B, the new proposed language, disclosure of lease and leisure, and unanimously agreed that that improved access to justice and unanimously supports that proposed language, but took no position on the proposed change in the discovery rules.
Mm-hmm. I would like to say that the 5 legal services and right to counsel providers who've made this proposal continue to advocate for both parts of it as revised. It was circulated last year to the Connecticut Bar Association and to the Citizens Advisory Council on Housing Matters before going to the Access to Justice Commission. Neither the CBA nor the Citizens Advisory Council on Housing Matters, which is run by Rafi Podolsky and includes both representatives of landlords and tenants. I believe that my colleague from Connecticut Legal Services, Jane Kelleher, is also part of that. Neither of those 2 bodies were able to reach consensus on the original proposal to take a position on it, but we did revise our proposal in light of comments received during that process. So you'll see there's track changes underlining. Our proposal now applies only to residential summary process matters. There was a lot of concern about commercial being different. Only the mandatory disclosure provision only to appearing defendants so that people can be defaulted if they don't participate. And the timelines for objections and production of discovery were made consistent to 15 days throughout those two rules, 13.7 and 13.10. And that was in response to comments received when we got to the CBA House of Delegates. We did have support of 2 CBA committees, legal services and legislation, but at the House of Delegates, they couldn't reach consensus. At this point, we would ask for this to move forward to public hearing. We've received a lot of feedback. Justice Bright was very wise in suggesting that after the passage of the new statute, 47A 3AD, which became effective July 1st, which requires landlords to provide tenants with a copy of their ledger upon request, that we get together and talk with court operations and judicial about language that would work. That resulted in the compromise language for the new provision 13-12B. We continue to believe that the shortening of the time for response or production of formal discovery is just a common sense measure. I know that some folks feel you can file a motion, but that does raise barriers for people who don't have an attorney. It takes more time for the trial judges, for the lawyers. So we would appreciate the committee's consideration, and we would appreciate at this point moving forward to public hearing. And I'm happy to respond to any questions.
Jima, one of the other significant changes I thought were from the original proposed language to this one is the revised language. The mandatory disclosures are only required in cases alleging non-payment or where there's an issue of financial obligations as to all.
That is correct. That is correct. That was compromise language that was worked out with Judge Thomas's help to narrow the focus of it to those cases in which non-payment is alleged or it's clear that there's going to be a repayment agreement that's negotiated for reinstatement. And that was a specific language that we worked out in our negotiations that Attorney Kelleher also was present for. Yeah, I'm happy to answer questions if folks have questions.
Anyone have any questions for Attorney Shea? No.
I should also say, I think, as I understood Judge Berger's concern, he felt don't want to misstate it, but if I recall, he felt that the continuance should have to be mandatory rather than discretionary, but Judge Thomas and others felt that the judicial branch should have discretion for all appropriate relief.
I think that Judge Berger's concern was on the service aspect, whether the service of the
That's right.
ledger would get to the defendant before the defendant had to answer
You're right.
the complaint.
You're right, Justice Bright. And my feeling, with all respect to Judge Berger, who obviously sat in housing many years, I think in our negotiated language, it does say no later than the first court date, this information must be provided. So to our way of thinking, this was either going to be served or provided at the first court date.
Okay. Right. Thank you. All right. So any thoughts on how you would like to proceed?
So
Andrzejewski?
I would just say I think that the changes and adjustments that have been made to address some of the concerns allay those concerns while still achieving the goal. And a lot of work obviously has gone into this. So I feel prepared to support sending it to a public hearing, but
Okay. Is that a motion to?
so moved.
All right.
Second.
Second. All right. Discussion as seconded by Judge Armada. Is there a discussion? And the motion would be to send to public hearing subject to technical changes.
Yes,
Okay.
thank you.
Any further discussion? No? All right. All those in favor, say aye.
Aye.
Any opposed? Any abstentions? Okay, that'll be sent to the public hearing. Yeah.
Won't be subject to a vote, but
Right.
will be for the committee.
All right, thank you. Thank you very much. Okay, the next item on the agenda is at 2024-016. It's a proposal for a new rule concerning gender inclusive and sensitive terminology to address the misgendering of individuals in Connecticut courts who are non-binary or transgender. You all have seen all the new materials that were submitted, including statements from each of the chief administrative judges. In particular, while they all support the concept, and 3 of the 4 all supported the proposed language that came from this subcommittee of this committee, Judge Bellis raised what I think are kind of significant operational concerns, and about whether this would actually solve the problem, whether judges are seeing the appearances, and typically judges don't see appearances unless they look for them, particularly when they're being e-filed, whether a judge will remember from the first time they learned of it to another appearance, perhaps years later, the information. So I think those are all very fair concerns that Judge Bellis raised, and I don't know how you all would like to proceed in light of her concerns, or she was, and I should also say that her comments indicated that she was in favor conceptually of protecting the interest that the proposal was directed to. So any thoughts on how you would like to proceed?
Would it be appropriate to send back to the committee?
I believe that I'm the only person left. That committee. Be happy to
Yeah, I think we'd have,
go further on that, but it seemed that Judge Bellis's comment required it to go back to the drawing board altogether.
yeah. So, yeah, I mean, I think that we could potentially involve court operations in this and figure out from a practical standpoint how we go about doing this. I think you need to have the judicial input that, like we got from Judge Bellis, but also the operational input. So I don't know if there's any two other people, let's say, who would be interested in being on a subcommittee with Judge Green to work with court ops and talk with Judge Bellis and report back to us on this. Judge Griffin, Judge Torres? Okay, so is there, can we have a motion to form the subcommittee? So moved. Is there a second? Second? All right, the motion is subcommittee of Judge Green, Judge Torres, and Judge Griffin to further consider this in light of concerns raised by Judge Bellis. Any further discussion on it? And all those in favor say aye.
Aye.
Any opposed? Any abstentions? All right, so the subcommittee is formed, and Judge Green, I'll ask you to serve as the chair of that subcommittee since you have some historic
Consider it.
history with this. Thank you. And then you guys report back whenever you're ready. The next proposal was next item on the agenda is 2024-20, which is the proposal for adoption of rules concerning the use of names and pronouns for attorneys, parties, and witnesses. We had always tied this to 2024-16. Is there a motion to do anything with this in the meantime? Table it?
Move that we consider it when we take up 20 or -16.
Okay. Judge Armada, second Judge Torres. Any discussion? All right, all those in favor say aye.
Aye.
Any opposed? Any abstentions? None? Okay, it passes. Next is 2025-004, which is a proposal to amend practice book section 41-9 to repeal the limitation on motions to dismiss. There was a proposal that was made, and then we had comments from Judge Pavia that was in the new material. I actually had a conversation with Judge Pavia this morning, and the thought is that she would like to have more time to look at the interplay of practice book section 41-9 and general statute 54-56. There is there's a case that talks about that interplay that was an appellate court decision from many years ago. And the thought is that just to overall look at how those two provisions work together might make some sense. Judge Pavia, anything you would like to add? She's on Teams meeting. Judge Pavia, anything further you would like to add?
No, I think you've summed that up perfectly. Thank you so much.
Okay, thank you. So is there, we'll just mark that over to the next agenda. Next item is 2025-009, which is a proposal to amend practice book section 7-19 to specify that a self-represented litigant can subpoena witnesses to depositions. Among the new materials was a comment from Judge Diana indicating that he has no objection to Judge Bellis's proposal, and a memo from Legal Services and proposed commentary from Attorney Greenbacker. The memo discusses the fact that these depositions can sometimes take place in juvenile and criminal matters in addition to civil and family, and it gives two different options. One would be to take out the phrase hearing from the language that Judge Bellis proposed to add on, or deposition, or to provide a proposed commentary, accepting, or if you decide you wanted to accept the changes from, or accept Judge Bellis's proposal, to add a commentary referencing the other provisions that would also be impacted by the rule change. Any discussion or? Yeah, Attorney Greenbacker is available on the call if anybody would like to hear from her.
Good afternoon.
Aye. Right, so does anyone have any questions for Attorney Greenbacker? Does anyone have a proposal they'd like to make at this time or discuss how they would like to go for it? Attorney Judge Griffin. Yeah.
Perhaps a question, I suppose, for the committee and or for Attorney Greenbacker, which is if we have the provisions out there in other portions of the practice book that already govern when self-represented parties can seek subpoenas from the court for depositions, what does this provision add to that? And how would they be read together? Because in this section 7-19, it would seem to place far fewer procedural requirements for the issuance of the subpoena compared to other sections, almost potentially rendering them superfluous.
Attorney Greenbacker, you wanna?
So the other sections that discuss subpoenas are not specific to an attorney or a self-represented litigant. It's more read generally that anyone can request a subpoena in the procedures in those particular sections. I think the original concern was the way 719 reads right now. It seems as though self-represented litigants can only seek a subpoena for hearings and not depositions because it doesn't say depositions. So to answer your question, I don't think that you necessarily need a change. It's just more if you're looking at it from the eyes of a self-represented litigant, it could seem slightly confusing that if you go to 719, it doesn't say depositions. It only says hearings. I did suggest removing hearings so that could be read more generally, just like the other sections are read generally. And we can certainly add commentary to direct people to the other sections if there was confusion based on where this is located in relation to those. But it's not a great answer to your question.
No, that's helpful. Thank you. I would just follow up because I think in some of those other provisions, you're right. It doesn't mention specifically self-represented parties, but like in 1327, in that area, for example, it does just reference a party generally, whether self-represented or represented. And if the question is to, or the purpose is to get information to the parties, then I wonder whether it would make sense to change a rule to provide that information or whether that should be something done through commentary or some other method. If the mechanism's already there under the rules, just a question of providing information to people who might need to use it.
The commentary is possible. We would, the commentaries typically go away after a year though. So we would have to think about whether we felt it necessary to kind of approve leaving the commentary in. But if we start that process, we could end up with rules with lots of commentaries, but
It could be very big.
yeah. Judge Mazurowski?
Somewhat of that discussion. Would it be helpful to put, because the commentary, first of all, I'm not sure everybody looks at it, it does drop away generally. Would it be helpful to put in 7-19, something like subject to the other other applicable requirements of the practice book? So as I understand it, this is kind of a section for self-represented parties specifically who must still then comply with any specific discovery rules of the various subject matters. So I don't know if that's a way to address it that would make it clear up front.
Add in the deposition language, would put subject to the provisions of and then list the other provisions identified.
Right. So it, instead of right now, what Attorney Greenbacker has in the draft commentary is, should be read together with the requirements of subsection or sections 1326, 1328, 2531, 34A20, and 40-44. We would just, the suggestion is to put those references into the body of the rule itself.
Just that might make it clearer that,
Right.
Alert or be aware there are other requirements that need to be met or procedures that need to be followed.
I think also parties' clarity is going to be very important. If they're not familiar with the practice book, they may not know that they have to also read into the commentaries on how to apply it.
Right.
Specifically for juvenile, you have to request court permission to obtain deposition. And I wouldn't want the self-represented party to get to read 719 and believe that they don't have to comply with those
I
specific.
still think that leaves the issue of thinking free about
This was
family or.
referred to Attorney Greenbacker to get some thoughts on whether there were any conflicts. She identified those. We could put her on the spot today and ask her whether the suggested change solves the problem, or if you'd like, we could ask her to look at it further to see if that solution has any unintended consequences for us or any issues that we might be missing.
Once we start
I-
listing them.
I can,
ahead.
I can look at it. Maybe another subsection to that effect might be helpful. I would add, Judge Bellis couldn't be here today due to a time conflict. It may be beneficial for me to look at it, in the meantime, to the next meeting, propose something to her so her and I can speak, since we had two different sort of theories on this, and then she could offer some more commentary on it at the next meeting since she's not here. And she did suggest different changes than what I was suggesting.
Okay. Is everyone okay with that?
Yes.
All right. So, and you're good with explaining to her what Judge Mazeroski and Judge Torres are proposed? Great.
Yes.
Very good. All right. Thank you very much. The next item on the agenda, 2025-011. It's a proposal for a new rule concerning notification of clients when a lawyer leaves a law firm. We have some comments from Statewide Bar Council. The CBA has asked that this be tabled to the next meeting so that they have an opportunity for their ethics committee to submit a response. Any objection to that?
No.
I just have a question.
Judge Wells?
As to a number of these new proposals and looking back at some of the old proposals. To get on the agenda or to get a number, anybody can submit a proposed rule and it will show up on the agenda?
Correct. Yep. So the next,
Subject to being screened for.
yes, yeah, we screen it to make sure we have jurisdiction. If they wanted us to do something that requires statutory or constitutional change, then we won't put it on the agenda.
But there's some vetting process.
That's basically the vetting process. If it's something over which we have jurisdiction, we will, unless it's something that appeared so frivolous that it wasn't worth it, then we would typically put it on the agenda and let everybody hear it. Yeah, I don't think we've taken any proposal and said, no, we're not going to present that this year. So, okay. Attorney Slack, did you want to be heard?
I have nothing to add, Your Honor. Thank you.
Great, thank you. All right, so the next proposal is 2025-13. The proposal to well, we'll table it till the December meeting. Yeah. Right. 2025-013 is a proposal to amend practical section 14-7A to be consistent with section 16 of Public Act 2025-78. Attorney Greenbacker, did you want to discuss this?
Yes, thank you. I had spoken to Judge Bellis about this, and I'm standing in for her for this proposal today. The Public Act did remove service by certified mail as an option for administrative appeals. So I am asking that we conform the rule to the newly changed statute. You should see on the last page of the materials, suggested change omitting the phrase related to certified or registered mail, and leaving just personal service left as an option.
Thank you. Any discussion? Is there a motion?
Move to send to public hearing.
Judge Welch, is there a second?
Second.
Judge Torres, any discussion? All right, all those in favor of granting the motion and sending it to a public hearing, say aye.
Aye.
Any opposed? Any abstentions? The motion passes.
Thank you.
Thank you. 2025-014 is a proposal to require professional liability insurance for attorneys. This is one where we did look at it to see whether this was something we had jurisdiction over. Different states do it in different ways. Some states have done it by rules, others have done it by statute. There's also an alternative to requiring professional liability insurance for attorneys that some states have pursued, of requiring attorneys who do not have a certain level of insurance to disclose that fact to their clients before they are retained by the client. That is something I think we could do by rule if we wanted to. This obviously would be a big change for the profession. I don't know how you would like to proceed. We would send it for referrals. We
I
could,
think we have to send it to referrals to the CBA.
all right, is there a motion to refer? Judge Armada, second. Judge Doyle. All right, who do we want to refer it to?
The Connecticut Bar Association.
The Chief Disciplinary Council?
Yeah.
Yeah, that's, and statewide grievance. So those are the three that I can think of. Is there anyone else you think we should send the proposal to? Okay. All right, so the motion, which has been seconded, is to refer the matter to the CBA, Chief Disciplinary Council and Statewide Grievance Committee. Any further discussion? All those in favor say aye.
Aye.
Any opposed? Any abstentions? Motion passes. The next matter on the agenda is 2025-015, proposal to amend all instances of videotape, audio tape, and tape recording in the practice book to align with current technology and practice. It's really just to get rid of the word tape, since except for some of us dinosaurs, no one knows what that means. So
Cassette or 8-track?
cassette or 8-track, right? Exactly. This is a technical change. So if there's a motion that's adopted, it would not be submitted to public hearing. We would just ask for the changes to be made to the practice book.
So moved.
Second.
Second. All right. Any discussion? All those in favor say aye.
Aye.
Any opposed? None. Any abstentions? None. All right. Motion passes. We'll have that technical change made. 2025-16, proposal to amend Rule 5.5 of the Rules of Professional Conduct to permit practice of law pending admission after attorney relocates from another jurisdiction. This proposal provides a kind of 6-month grace period. Attorney Vance, I didn't know. Attorney Vance appeared on the screen. I didn't know if he wanted to be. Yeah, Attorney Stovall, did you want to be heard on this? She was there. Yep, there she is.
I'm here. Hi, I'm happy to answer any questions. I don't know if you want me to give a little explanation of why we think this rule is necessary. Maybe this is not the point to do that, because I might assume that you'll send it out for comment to disciplinary council and statewide grievance. I'm happy to address any questions you have now or talk about it in any way, but I'm assuming that the point to do that will probably come later after disciplinary council and bar council have weighed in.
Okay. And does anyone have any questions? Attorney Harrington has appeared on the screen. I didn't know if she wanted to be heard at all at this point.
Thank you, Your Honor. I'm Kathleen Harrington. I'm Deputy Director of Attorney Services. I would also ask that this be referred to the Connecticut Bar Examining Committee for comment, in addition to the Office of Chief Disciplinary Counsel and Statewide Grievance Committee.
And I apologize, I meant to say that.
Yes. And maybe the bar association as well.
It's the Bar Association's proposal, so it's the
that's
proposal.
true. Yeah, that's true.
Bar Association, so Bar Association has already weighed in.
Right. Attorney Vance?
Your Honor, yes, thank you for allowing me. Attorney Stovall did a nice job of just saying what I was going to say, that I'm here as a representative of the Bar Association. It passed unanimously, both through the LPRC committee as well as through the executive committee, the House, and the Board of Governors. So the Bar Association gives it a thumbs up and looks forward to others' comments on this.
All right, so is there a motion for referrals? Judge Doyle? And second, Judge Mazurowski. So the motion is to refer the matter to the Chief Disciplinary Council, Statewide Grievance Committee, and the Bar Examining Committee.
Yes.
Right. Any discussion? None? All those in favor say aye.
Aye.
Any opposed? Any abstentions? Okay, it's referred and we'll wait to hear reports back. So the last item on the agenda is miscellaneous. Such other matters as may come before the Rules Committee. Does anyone have any other business to take up today? Let me just, I do appreciate you all coming in and giving the in-person a try. We're going to be out of here in about 40 minutes. Was it worth the trip? Do you still want to do it in person, or would you like to do the next meeting in December remotely?
So it's great to see everybody, but remote is easier.
Okay. All right. So what we'll do is we'll do the next one remotely, and then we'll talk about if we get to a point for either January or February, if we want to be in person because we're getting down to the end of the year and we want to all be together to kind of put fine points on things, we can do that. But for the December meeting, we'll do it remotely. Okay.
Sounds good.
All right. Is there a motion to adjourn?
So moved. Second.
All in favor?
Aye.
Any opposed? All right. Thank you all.
Thank you.
See you. We are adjourned.